Good morning, everyone. I'm going to ask you to take your seats as we are ready to start our Intergovernmental Relations Committee meeting. My name is Elizabeth Glidden. I am the chair of this committee, and I'm joined today by council members Fry, Cano, and Andrew Johnson, and we are a quorum of the committee. We have two items on our agenda for today. The first is a very short item, which will be updating our city's legislative agenda. The second is a lengthy item where we will be discussing the White House executive orders relating to immigration enforcement and refugees from January 2017. And I have an item that I am going to add to the agenda. So I'm going to move to amend the agenda to add a resolution by myself, and I know that other council members may want to be added to this, and this would be a resolution condemning the January 2017 presidential executive orders on immigration enforcement and refugees. And to add that to the agenda, all in favor, please say aye. Aye. Opposed? And that is added to our agenda as item number 3. Just a couple notes, which is that if people are continuing to arrive, we do have some additional space in room 319, and we also have available some interpreters for those who might need it. And I think we're over in this area or right outside, and so we will accommodate you if you need some assistance in listening to the meeting. So first, on item number 1, I think I will just read this. This is approving an additional amendment to the City of Minneapolis 2017 state legislative policy positions. And this is in response to some recent bills that have been offered at the state legislature. And the policy position addition is the City of Minneapolis supports the rights of all people to engage in protected First Amendment speech, assembly, and protest without the burden and risk of civil liability for public safety response costs. So all in favor of, well, let me just ask, I will move that, and is there any discussion on that item? Seeing none, all in favor, please say aye. Aye. Opposed? And that item has been added to our agenda. I'll note we've been joined by committee member, Council President Barbara Johnson, and we have also been joined by Council members John Quincy and Lisa Bender to listen to this committee presentation. So we now are going to turn to some presentations relating to the White House executive orders. And I might ask Mr. Ranieri if he would like to just give an overview of what we're about to discuss, and then we will have, we will talk about kind of what some of the order of the presentations. Mr. Ranieri,
Madam Chair,
if you want to introduce yourself.
Yes, Madam Chair, members of the committee, my name is Gene Ranieri. I'm the Director of Government Relations for the City of Minneapolis. As you're aware, during the first week of the President's presidency administration, several executive orders were issued dealing with immigration. One dealt with protecting the border, one was with refugees, and then the third was dealing with, it's entitled Internal Security of the United States. It does a lot about enforcement of immigration. It talks about sanctuary cities, which is right in the executive order. We're going to have today is presentations by our city attorney, who will talk about the executive order dealing with cities or so-called internal immigration. Also, we have some folks from the legal community, the advocate community, to talk about the other executive orders, as well as some folks giving some testimony about what's occurring in the two communities. And in addition to that, there will be some resolution and a direction, staff direction. And this is going to be a continuing thing, as you're aware. This afternoon, there is a court hearing in Seattle or San Francisco dealing with the orders, and the federal district court will be making some decisions later today.
Okay. Thank you very much, Mr. Ranieri. And I think we will have Ms. Siegel go first. I apologize. I think, and then after that, we're going to have a presenter who is not sure how long she's able to stay, so we're going to take her first. after Ms. Siegel. Since he's getting you set up, why don't you go ahead and go, since I don't think you're that long.
Okay. Yeah,
And introduce yourself, please.
Okay, I am absolutely fine either way. So on January 25th, as we all know, the president issued an executive order dealing with sanctuary jurisdictions. And the first thing I want to point out is that this is the statement of purpose at the outset of this order signed by the President of the United States. And what it says is that sanctuary jurisdictions across the United States willfully violate federal law in an attempt to shield aliens from removal. And it goes on to say that these jurisdictions have caused immeasurable harm to the American people and to the very fabric of our republic. That is a direct quote from the outset of this executive order signed by our president. So what is a sanctuary city? It's a loose descriptor. It is not a legally defined term for cities that have adopted various ordinances to separate their activities from the federal government's job of enforcing federal immigration laws. So all that these ordinances do is decouple local law enforcement and other efforts from what is the job of the federal government, which is to enforce their own civil immigration laws. The goals of these ordinances, and there's quite a variety across the country, but generally it's to allow residents to access city services for which they are eligible. I will put an emphasis on eligible. Nobody is unlawfully providing federally funded benefits to undocumented residents of Minneapolis without fear of immigration consequences. And what's important, particularly to my office and to the work of our law enforcement officials and to the public safety of the city of Minneapolis, is that it also protects public safety by allowing undocumented residents to report crime without fear of immigration consequences. One thing that our office has placed a heavy focus on is that of prosecuting domestic violence cases. This is a very important tool, our separation ordinance, in being able to get help and information that we need to be able to prosecute these cases. Our city also has taken a lead role with juvenile sex trafficking enforcement and prosecutions, also very critically important there, as well as a whole host of other crimes. And what's interesting to me is that our federal immigration laws recognize this importance because they have a program called the U Visa program. And this is still up on the website for the USCIS, where if you have been a victim of a crime and provide assistance to law enforcement or to prosecutors in connection with that crime, that you can get a visa to lawfully be in this country. And here this says, don't be afraid to ask for help right off the federal government's website. Immigration relief is available for victims of human trafficking, domestic violence, and other crimes. So I think that's important to just point out at the outset as we talk about this executive order. And first I'm going to talk about the provisions of the executive order, then describe briefly our ordinance, and then talk a little bit about where, as far as we can tell, we think we stand right now under this executive order. So what does the executive order provide? Section 2, the policy statement, says that it's to ensure that jurisdictions that fail to comply with applicable federal law don't receive federal funds except as mandated by law. So the big question is, how will the federal administration interpret and apply this policy? The major provisions of the executive order is that the Attorney General and Secretary of Homeland Security shall ensure that jurisdictions that willfully refuse to comply with 8 U.S.C. 1373, and I know this is getting into the weeds about laws, and in a minute I'll tell you what's in 1373, but this is a linchpin here of importance in trying to figure out what's going to happen, are not eligible to receive federal grants except as deemed necessary for law enforcement purposes. There's some discretion allowed to the Attorney General to figure out which grants really are important generally for law enforcement purposes, such that they will allow those funds to flow even to so-called sanctuary jurisdictions. Next, this section also states that the Secretary of Homeland Security is authorized to designate in his discretion and to the extent consistent with law a jurisdiction as a sanctuary jurisdiction. Huge unknown and a major red flag there of what will be deemed sanctuary jurisdictions in the discretion of the Secretary of Homeland Security. The main provision, Section 9, contained also in Section 9, is that the Attorney General, and I put this in really big letters and in bold, because this is a key provision here, the Attorney General shall take appropriate enforcement action. We have no idea what that means, against any entity that violates 8 U.S.C. 1373, or, and this is a huge or here in this executive order, which has in effect a statute, policy, or practice that prevents or hinders the enforcement of federal law. Obviously, another very concerning provision. So what is 8 U.S.C. Section 1373? It's a provision existing in our immigration laws now, and has been, that bars state or local jurisdictions from prohibiting or restricting any governmental entity or official from, and it's very specific in what it does, sending to, requesting of, or receiving from the INS, and it does have Immigration and Naturalization Service, even though that doesn't technically exist anymore. It's been split into 3 parts and divided over different parts of the federal government. Information regarding citizenship or immigration status, maintaining such information, or exchanging such information. And I'll get back to this, that section in a minute when I compare it to what's in the Minneapolis ordinance and whether we're in compliance or not. There are miscellaneous additional provisions in this executive order, hiring 10,000 additional immigration officers subject to availability of appropriations. It terminates the priority enforcement program, which there's 2014 guidance, which really prioritized violent crimes first and upends that a bit. I'm not going to talk about any of this because we have actual immigration experts here. John Keller, Robin Phillips from Minnesota Advocates, but it alters and expands the categories of priority for deportation. And it also encourages the federal government to engage with state and local governments to enter into voluntary agreements, so-called 287G agreements, to aid in enforcement. So another unknown is what carrots will be bestowed on these jurisdictions and withheld from other jurisdictions who do not go down that same path of taking on the federal government's work for it. Other provisions I felt are just worth noting is that it requires a weekly report to be published that contains a comprehensive list of criminal actions committed by aliens in any jurisdiction that ignored or otherwise failed to honor any detainers with respect to such aliens. And it creates a new office in Immigration and Customs Enforcement to support victims of crimes committed by removable aliens. So what's in the Minneapolis ordinance? What does it provide? The city of Minneapolis has had a separation ordinance since 2003. And I'm going to start out by saying what it does not do. It does not protect people who commit crimes from either arrest or prosecution for those crimes. There's a lot of hysteria, a lot of misinformation, so I thought it was important to just put that out there. And as I already mentioned, it does not provide public benefits for ineligible persons. The city of Minneapolis does follow the law, including constitutional federal law, and will continue to do so. But that doesn't mean that the city of Minneapolis is obligated to undertake actions on behalf of the federal government that interfere in a constitutional and lawful way with some of the goals of the city of Minneapolis. So our ordinance for general city services prohibits city employees from soliciting information about immigration status, except when specifically required to do so by legal requirements for eligibility for the service sought. It also provides that city employees shall not use city resources solely to detect or apprehend persons whose only violation is being undocumented. And I do want to point out that being undocumented is a civil violation. That's part of the civil federal immigration laws. That is not a crime in and of itself. For public safety officials, it prohibits taking action only for the purpose of determining immigration status. It prohibits the questioning, arrest, or detention for violation of federal civil immigration laws, but it does not prohibit actions related to criminal enforcement, such as a provision of the federal law, 8 U.S.C. Section 1324, which are the criminal provisions relating to smuggling and trafficking of undocumented persons. So if it's an element of the crime, our police department has the right to inquire about immigration status in order to help control crimes such as smuggling of human beings and the trafficking of human beings. So what is the impact? Does our ordinance violate federal statutes? And Minneapolis does not violate federal law based on current legal precedent. 8 U.S.C. 1373 only prohibits state and local jurisdictions from imposing restrictions on the sharing of information. Our ordinance only restricts the gathering of this information unless, as I already said, related to a criminal offense. So based on any reasonable constitutional interpretation of 1373, and it's also possible that 1373 itself is not necessarily a constitutional provision, Minneapolis is not in violation. Our separation ordinance does not violate this section of federal law. So we should be okay, one would think. However, as I pointed out before, the big unknowns are that Section 9 refers not just to compliance with 1373, but to any statute, policy, or practice that prevents or hinders the enforcement of federal law generally. And then this other provision already quoted that the Attorney General shall take appropriate enforcement action on that basis, and that the Secretary of Homeland Security has, in his discretion, the right to decide what's a sanctuary jurisdiction. Something else that I think is important to point out, City of Minneapolis does not operate a jail. That is operated by the Hennepin County. And they've gotten good advice from their county attorney on when they can and when they constitutionally are not allowed to honor detention requests. But arrest and detention requests, since our ordinance does restrict arrests solely on the basis of civil immigration status, just these detention requests without there being an actual warrant or a judicial order are unconstitutional. And so I think that's important to keep in mind as well. And we have a very recent case out of our federal district court here right in the state of Minnesota, Orellana v. Nobles County, with that very conclusion, and that's a decision issued on January 6th of this year. Finally, we're all suddenly becoming familiar again with the 10th Amendment of the United States Constitution, which contains limits on federal authority. For those of you who are armchair U.S. historians, an important part of our history is what powers does the federal government have over state and local jurisdictions. And there have been some helpful precedents coming out of our U.S. Supreme Court on these very issues. So there's this notion, you may have heard the term in the media recently, of commandeering, that there are limits on the federal government's authority to commandeer state or local jurisdictions to administer or enforce a federal regulatory program. We believe that chain of cases under the 10th Amendment is very applicable here. Also, there are limits on the federal government using the spending power as a threat to coerce compliance with federal mandates. So threats to withhold significant funding or that you can't participate in significant federal funding at some point, the courts will struck down as being overly coercive and violative of the spending clause of the federal Constitution. The recent example of that is the U.S. Supreme Court's decision under the Affordable Care Act, where threatening 10% of a state's budget that you withhold Medicaid funding, the U.S. Supreme Court decided was coercive and violated the spending clause of the Constitution. So where are we left? Despite court precedents, there's a lot of unknowns of how this federal administration is going to go about implementing this executive order. So there's much yet to be seen, but from the language of the order itself, there is a lot to be very concerned about. It really is, in my decades of legal practice, unprecedented, these executive orders in their wording and scope and breadth. The city of San Francisco last week started a lawsuit raising many of the issues filed in federal district court out in California, many of the issues that I've just reviewed.
Okay, I apologize. So thank you very much, Ms. Siegel. I will just note for folks is that we will be attaching to our public agenda all presentation materials. Those are not available right now, but as the presenters have come through, now they have their presentations finalized. All that information will be attached to the public agenda. We do have several presenters today, and we have some that have some time constraints, and so I'm going to ask if we can try to get through our presenters to make sure we can hear the information they are going to share with us. It is a lot of information, and it is a complicated landscape that we are trying our best to understand, as well as being able to hear some from those who are very connected with community and community members who are impacted. So our next presenter, we are going to take a little bit out of order, but she has a time constraint. And so we're going to ask one of our community presenters to come forward. She does have a presentation. I don't know if she needs some assistance with that. This is Amelia Avalos from Navigate, Minnesota. And thank you very much for joining us.
Thank you very much, members of the council, Madam President of the committee and the council. My name is Emilia Gonzalez Avalos. I'm the Executive Director of Navigate, Minnesota. And I have most of my information is a community perspective of how we are understanding these executive orders, and then also some personal stories about the people that are residents of the city, but that will be deeply impacted by our lack of action in these orders. So as you heard from the Attorney General, City Attorney.
City Attorney.
City Attorney. This is a response to the promise to deport 2 to 3 million undocumented folks and the executive orders that lays out the conditions for removal. I have some stories. The first story, I omitted the names. I call her the matriarch. This is a woman that migrated to the U.S. in the 80s, and she missed the opportunity to apply for the Ronald Reagan amnesty because she didn't have money. She's an elder, as you see. She has some grandkids that actually benefited from the DACA program, and she doesn't have a pathway to citizenship or residency at the moment. She has been living in the U.S. for over 25 years. She has arthritis. She depends on selling sometimes food or cooking food for folks. She's getting older. She's sick. There's no immigration remedy for her. And I quote her words, "I will never be an American." The matriarch spent most of her productive years working in cooking shops, restaurants, washing dishes, both in the state of Minnesota and Illinois. And she is looking, so the request when I spoke to her was, what does it mean for you to provide some kind of city protection for you? And she says that she's older, that for her dignity means many things, but basically how the city is going to protect her for her making the choice that if she's going to be removed, she's not going to be shackled and sent back in an airplane. She is actually a constituent of Mrs. Cano, and she's a homeowner. She's been living her home for about 10 to 11 years. And then we have the Vindicated. He's a male. He's 46 years old. I believe he is Mr. Guarsame's constituent. He committed, he was charged with a DWI over maybe 15 to 17 years ago. After that, he went to the court. He fulfilled his duties. He had some community service work that he had to do. And not only he stopped drinking, he also committed most of his time to community service work for his church. He's one of his church leaders. He is a father of 3 U.S. citizens. But because of this conviction that happened over 10 years ago, he is still in the threat of deportation. He's one of what the media calls criminals. And he is creating a plan on how he is going to have to, first of all, save in case he needs to go, and how his children are going to pursue their college education in case he's removed. The next one is what the Pew Research Center calls the super undocumented. These are folks that migrated to the U.S. after, like the first wave after NAFTA. They are mostly parents of the Dreamers, so the parents of the folks that organized for the DREAM Act, federal and statewide. They don't have, according to the Pew Research Center, they don't have U.S. citizens' children. They migrated after their 30th birthday. They have been at least 10 years to 15 years in the country. And because they don't have what the federal immigration law calls ties to the U.S., again, there's not an immigration remedy. There's no pathway for citizenship. And they still work, janitorial work, housekeeping work, restaurants, maintenance, construction. The next one is what I call the one with so much future ahead. He's a male. He's 19 years old. He's actually a constituent of Mrs. Glidden. He was waiting for the 2014 executive orders that will increase the safety net for kids that arrive before the age of 16 and had been in the state, haven't committed any crime, and it will be what we call the DACA Plus. That was the executive order in 2014 that will raise the age cap of the DACA program and then move the entry date from 2007 to 2010. He was still in junior high when there were conversations about that program. So he ramped up his classes. He went to higher level classes at school. He took IB, AP, and he graduated last summer. And he's right now in community college with a full scholarship, but still, he doesn't know that he can pursue his medical field because he doesn't have a work permit, and he has to pass some background checks to be able to get some of his certifications to keep moving on. The next one is the fears. She's a transgender woman. She came to Minnesota in 1996. She went to Southway High School. She washed dishes at night, and she became her fully self, as she says, in Minnesota. She was deported for walking, what she calls walking by being trans. And because of her gender identity, he was put in solitary confinement for some time. Because she had been deported, she went to Mexico, and she came back because the state where she's from is one of the most dangerous states